This bill is incredibly personal to me. I'm the mother of 2 children. However, I had several unsuccessful pregnancies, and in fact, when I had my son, I spent 3 months on bed rest before he was born, and dehydration was the factor that was cited in pushing me into premature labor. There were other factors, but I sit here today as a witness of staying off your feet, staying hydrated, or avoiding heavy lifting can be the difference between having a healthy baby or going into premature labor and possibly having a severely premature baby, which was what I was at risk of. And just thinking about all the costs and complications associated with that, or even having a miscarriage. The bottom line is that women should never have to make the choice between ignoring a doctor's orders or keeping a job. And sadly, it's low-income families that are most vulnerable when these simple protections don't exist. That's why the Pregnant Workers Fairness Act is so important. In Nevada, where I come from, over 64% of women are the primary or co-breadwinners, and these women are more likely to work low-wage jobs. A woman in Nevada is over 60% more likely to work a low-wage job than a man. And when a pregnant woman's forced to leave her job because she didn't receive reasonable accommodations at work, it's their families that are forced into live without health insurance or income during a time when they need it the most, as Ms. Durham had explained. The current legal loopholes have already been highlighted here today, and it's clear that working mothers and businesses need the clarity to ensure that pregnant women can be accommodated. These accommodations are simple, like a stool to sit on, an extra bathroom break, perhaps a larger uniform to accommodate a growing baby, or even carrying a water bottle onto the floor. Working women who are pregnant don't have the time or the resources to take these matters to court and work through this litigation to receive these accommodations. And Ms. Durham, first of all, I am sorry that you had to go through that process. And I personally get frustrated thinking about the life that you could have had in the job that you trained for had these accommodations been made to you. So thank you for that testimony. I appreciate it. Ms. Wilbur, I just wanted to, you described how Kentucky had passed a version of this bill, and it was supported by businesses who recognize the economic benefits of providing clarity and uniformity on the issue of reasonable accommodation. Can you tell us what were the employers' initial worries about the costs of providing these accommodations?
Thank you for your question. And so this was sort of a long journey for our Metro Chamber of Commerce. And I always like to kind of set the stage. We have heard about these issues bubbling up across the country, and some folks had approached our Metro Chamber to explore this issue. And so after some conversations among our membership of all sizes, of all different sectors and industries, we learned pretty quickly that because we had a whole list of questions that we needed this type of clarity. For our membership, when you have a bunch of questions, a bunch of concerns, a lot of uncertainty, that means dollars, and that in a bad way. And so being able to work on the Kentucky legislation to provide the framework of when an employer is and is not obligated to provide accommodations was extremely significant. Like I said in my testimony earlier, particularly for small to mid-sized businesses that can't afford a robust HR department or a large legal counsel, our people just want to run their businesses. And so being able to work on the Kentucky legislation with our General Assembly to define the undue hardship was extremely significant because we are talking about providing a stool. Are we talking about $4,000 stool? No, we're not. We're talking about providing access to water, so having a water bottle at a station. These are low-cost, reasonable accommodations, and guess what? They're temporary. And so when we were able to message that, not only to lawmakers, but also the business community, we got the feedback, we're sort of already doing this because we want to do the right thing as a business community. But if we can get some framework in state statute to clearly define when we are or are not obligated to do these things, that is a welcome addition to Kentucky law.
Thank you. You also highlighted the economic benefits of helping women remain in the workforce and the benefits of employers when women are able to continue to work safely. How is ensuring pregnant workers having reasonable accommodations a tool to increase women's labor participation, and what does that mean for the economic outcomes, not just to both businesses, but also their employees?
So in Kentucky, unfortunately, we have one of the lowest workforce participation rates among women. And when we looked at the population that are currently in the labor force, we know that over 58% of them are of childbearing age. So these are conversations that are happening already. And so we ask ourselves, particularly as a Chamber of Commerce, if one of our top priorities and initiatives that we're hearing from the business community is that talent pipeline, workforce development, talent attraction, we need to have certainty in statutes to allow employers to know when they are not obligated to provide these accommodations, but also to ensure that women that are pregnant or new mothers that want to work are able to work. And so we think this is a reasonable law, particularly at the federal level, to provide that uniformity and clarity across the board is significant, particularly for our Chamber of Commerce. We're a bi-state Chamber of Commerce. We represent 5 counties in southern Indiana. So being able to have that clarity across the board is significant.
Thank you. My time is up. I yield back. Thank you.
Thank you.